Hey guys, welcome to Hughes History as we hit you up with some Supreme Court precedent today as we get in the time machine and go back to 1973 and take a look at the court case Miller versus California and see if we can test the constitutionality of creepiness. That's right guys, we get to define what's obscene and what's free speech in today's lecture, looking at the Miller test. So I hope that you guys are excited, not in a creepy way, as we try to grow our brains 10 times its size. So why don't we go giddy up for the learning and go get her done right now. All right, guys, why don't we define the constitutional issues first, then we'll go backtracking a little bit. How about that? And the real constitutional issue is, number one, is obscenity protected by the First Amendment's freedom of speech clause? That's the first question. And then the second question is, if it is not, how do we define obscenity? And there is a split Supreme Court. There is a 5-4 split in 1973 with a majority that's going to be led by Chief Justice Warren Burger, which is going to argue that it is not constitutionally protected and there should be some type of guidelines that allow states and localities to charge people if they believe that it has met this standard. So that's what we're going to kind of do in this lecture. But the first thing that I would like to do is kind of go backward to see how we're going to work our way up to California versus Miller in 1973. So you ready? We're going to go back. We're going to go back. We're going to go way back to like the 19th century with all the poofy dresses and everyone was uptight and such. So in 1973, we're going to define obscenity and actually change the precedent of the court case called Roth versus the United States that was put down as the law of the land in 1957. But believe it or not, kiddos, there was a time before the 1950s, and before the 1950s, before Roth, we used something that was called the Hoechlin Test. And that actually generates from English common law, so you can go back to Great Britain. That's the worst accent ever. And you have to go back to 1857 with the Obscene Publication Act. It was also called Lord Campbell's Act, which basically defined for Great Britain how they were going to get rid of what they called obscene material. And there was a court case in England that was generated from this called Regina versus Hoechlin, the Hoechlin Test. And the Hoechlin Test, this was in 1868 in Great Britain, but it's going to be used by the courts in the United States. And you can see how they're going to define obscenity. And here are the words right now. A tendency to deprave and corrupt those whose minds are open to such immoral influences, and to whose hands a publication of this sort may fall. So if someone of a dirty bird gets hold of your stuff, and it makes them a dirtier bird, then it's labeled obscene. And it was actually a court case that was challenging anti-Catholic literature that actually had some racy stuff inside of it that related to confessionals where the priests were asking women detailed questions about their sins. Do you understand what I'm saying? Hug. And the argument from that side was, hey, you know, we're not doing this for sexual gratification reasons. We're doing this because we're trying to expose corruption. And the court said it doesn't matter. Context doesn't matter. Intention doesn't matter. What matters is if, someone with a tendency to be a dirty bird gets a hold of this and uses it to be a dirtier bird. They didn't use the dirty bird analogy, but you get what I mean. So this is a very, very broad interpretation of what would be labeled obscene. The government could really use this to gobble up lots of dirty bird stuff. But this is what's going to be used in the United States, especially after the Comstock laws were passed in 1873. This is Anthony Comstock, and he's really wanting to clamp down on what he considers obscene pornographic materials, which also included literature that related to abortion or birth control. He doesn't want this going through the U.S. mail. He thinks that it's the job of the government to legislate, to regulate, to confiscate, to get rid of this dirty bird stuff. And Rosen versus United States in 1896 fully adopted the Hoechlin precedent, which we talked about before, the Hoechlin rule. So that's the law of the land, and the federal government and state governments were really allowed to go after whoever they wanted to. So in 1957, we're going to overturn the Hoechlin rule with Roth versus the United States. Now, this was a 6-3 decision written by William Brennan, who's going to be on the losing end of Miller. So he's more of a liberal justice. He wants a stricter interpretation, let's put it that way. He wants the words to be really clear. So while he's going to uphold the idea that obscenity is not freedom of speech, and that's the precedent in Miller as well, he is going to define it in a way where it's going to be able to breathe a little bit, if you know what I mean. So the two rules in Roth are you can ban it if it has utterly no redeeming social importance. It's just nothing but dirty, man. And then they come up with the community standards kind of phrasing, and you can hear those very important words right here. That to the average person applying contemporary community standards, the dominant theme of the material taken as a whole appeals to prurient interests. Now, I had to Google that word, prurience. I had to Google how to say it and what it means. But it means dirty bird stuff. It basically means that you are appealing to just this sexual compulsion and sexual nature. So there's two rules. It has to be utterly without social importance, and that if it's offensive to contemporary community standards, then you can ban it. So that language becomes very broad. It's hard for states and localities to go after people trying to prove both of these things. And then we get, the 1960s. And there's hippies and dirty bird stuff going on, and it's on the TVs and such like that. And that actually becomes a campaign issue. In 1968, there was one of the first huge contentious nominations when Abe Fortas was nominated by LBJ to be the Chief Justice, and this issue came up. And Strom Thurmond, I believe they launched a filibuster against the guy. And it was really based on these ideas that the Warren Court was just letting people fly their freak flags too much. You had to give some power back to the states in order to put our grip around all of this crazy social nonsense. Now, in 1966, Roth is going to get a little bit of a dust-up in a court case called Memoirs versus Massachusetts, where the court's going to add some language to how we define obscenity. They're going to say it has to be patently offensive, without a doubt, and it has to be utterly without any redeeming social value. So there's not enough of a majority opinion to formulate a new rule, but that is going to make it a little bit more defined as we go into the 1968 elections. So that's what's going to happen as we fly into 1973 with a new Chief Justice, Warren Burger, appointed by Richard Nixon. And now you're probably about ready for the stupid Miller test. What am I waiting for? Waiting too long. I'm going to do it right now. So in 1971, Marvin Miller, he has a catalog company, he's sending out dirty bird stuff in the mail, and it ends up in a restaurant in Newport Beach, California, where the son opens it in front of his mom. It was probably really awkward, and they call the police. And California Penal Code 311.2, how do I remember that? I don't know. But this was the law that was written that classified sending obscene material as a Class 1 misdemeanor, and the law was written according to the language of the Roth case, of Roth versus the United States. So it's tailored to the Supreme Court specifications. They got the guy red-handed, they arrest him, and he ends up being found guilty. And that's the court case that's going to make its way up the ladder to the Supreme Court, where poor Marvin consistently loses. That's why it's Miller versus California. So now we have a new court case, and this is going to give Chief Justice Warren Burger the opportunity to find some language that's going to be a little bit more broad to give state and local prosecutors the ability to go after people if they so choose. Now, at the end of the day, they're going to uphold Miller's conviction. And Miller actually brought up that it was Memoirs versus Massachusetts that he was being denied because the jury was not instructed about the new language. But they say, either way, you can go have a new court day, that we're still going to find that, number one, this is the big constitutional question, that obscenity is not free speech. They're going to agree with Miller. Brennan, at this point, has actually gone into dissension. He's joined some other justices in the four losers, saying that He's just given up trying to regulate this stuff. So Berger's going to write the majority decision, and they're going to come up with some rules. Are you ready for some rules? Why don't we take a little musical break as we get a new section, the Miller Test. We're finally there. You made it. Thanks for watching. Here we go. The Miller Test. So here it is, guys. It's the Miller Test. There's 3 rules if you want to find something obscene and ban it, and you have to check off each box. You can't be like, I got 2 of the 3. You got to get 3 of the 3. Number 1 is contemporary community standards. This is some of the language that comes from Roth, but they say if it's taken as a whole, if it's only appealing to this prurient interest, it's only dirty bird stuff, and it's a contemporary community standard, an average person in a regular community can understand that this is just all dirty bird stuff, then you can check that box off. Number 2, if the work depicts in an offensive way sexual conduct or excretory function. I don't even want to define those things, but it shows the dirty bird stuff or things that are involved in the dirty bird stuff doing dirty bird stuff. You get the idea. So if you can check that off, you can go to number 3. And number 3 is really important. You can read it right here. The work taken as a whole lacks serious literary, artistic, political, or scientific value. That's the Miller Test. So it's supposed to be kind of a grand bargain here. So if it's in New York City and that community wants to allow that sort of stuff, they're not offended by that stuff, they see value in that sort of stuff, they can allow that. But Topeka, Kansas, probably not. And as we've gone through the 1970s, the 1980s, and the 1990s, communities have come up with kind of their own way of dealing with this. So that's the Miller Test. But now kind of why don't we fast forward to the 21st century, bring up some ideas, and then ask you about the dirty bird stuff down in the comments below. How about that, kids? So if we fast forward today, certainly there's a lot to talk about. We'll just kind of bring up a few issues, but certainly the internet is one of them. Now, when it comes to local issues, that's usually intrastate, state issues. If you're sending it, just in your community, you open up a store that sells dirty bird stuff. But the feds have kind of had the power over interstate. And now we kind of bring this into focus. Community standards, contemporary community standards. So if I post some dirty bird stuff in some type of forum with a community of other dirty birders, that's not offensive to that community. But certainly if someone in a small town in western Pennsylvania goes on and finds offense to that, it kind of can fall under that umbrella. So this happened in 2002, actually. PBS was filming some porn producer who made some outrageous dirty bird stuff, and the porn producer actually challenged John Ashcroft, the Attorney General. Come at me. Go ahead, come at me. So they came at him, and they charged this guy in U.S. v. Extreme Associates, that's the court case, in western Pennsylvania using their community standards. Now that actually got a plea bargained out at the end of the day, so we really haven't framed this and figured this out, even to today, how we deal with obscenity, pornography on the internet. Now certainly there are people that are going to argue that this is very vague, and vagueness can have a chilling effect on freedom of speech, that I might be worried what's going to be the effect if the government's going to come after me if I produce this work of art that somebody, in some other part of the country can find offensive. So that would be another issue. And certainly we bring up this idea of, what is value, a social value. That's something that's very intangible and very interpretable to different types of people. And then at the end of the day, we go back to this argument about whether the government should be in the job of promoting, social orders. That unless someone's getting hurt, it's non-consensual, it's children involved, that would fall under strict scrutiny. Like everybody would understand why we had laws to do that. But there are people that argue that we shouldn't be trying to police obscenity other than those exceptions. We should have a strict scrutiny rule. And then there's other people that say that's just cray-cray. We need to have some structure. What do you guys think? Put it down in the boxes below that the internet uses to allow you to participate in the 21st century. How about that, guys? There you go. We hope you're a little smarter. We certainly hope that you understand the Miller test, the three-prong rule put down in Miller versus California in 1973 that determines whether or not something's dirty bird stuff, whether it's obscene and unconstitutional. How about that? And we certainly hope that you haven't subscribed, that you do that right now, because it's the right thing to do. And go check out the video arsenal. We have over 420 videos. It's just a little bit nuts. And I'm going to say it because I say it at the end of every lecture I've ever done, because I mean it with all my heart. Where attention goes, energy flows. We'll see you guys next time that you press my buttons.